proceed.
May it please the court, my name is Greg Barrison. I represent the plaintiff appellant, Humberto Herb Correia. Had things gone the other way, had Mr. Correia challenged his conviction on the ground of ineffective assistance of counsel and been denied, he would have no case. The rejection of an ineffective assistance of counsel claim, an undisturbed guilty verdict, would doom his subsequent civil legal malpractice claim against his former criminal defense attorneys. But that stone got rolled away, and Mr. Correia deserves his day in court. Massachusetts law sets the bar very high, and Mr. Correia cleared it. Absent post-conviction exoneration, he could not bring a claim for legal malpractice against his former criminal defense attorneys.
Do you agree he has to show a proof of innocence?
Yes, Your Honor. In addition to the usual elements of a legal malpractice, he has to establish that he was actually innocent of the charges by a preponderance of the evidence.
And how did he do that in this case?
The evidence offered at the summary judgment included the testimony of the witnesses who were known to the attorneys who handled the first trial.
But they did not testify in the first trial.
Correct. And Mr. Correia got his second chance because a wise and courageous jurist, the Honorable Raya Zobel, sua sponte, raised the issue of whether Mr. Correia had been adequately represented. And I asked, what more could Mr. Correia have done? He was acquitted at his second trial on every charge against him.
Well, surely the fact of the acquittal is not evidence.
Absolutely, Justice Cordy. We agree that that does not settle the issue.
It's not even evidence on
No,
the
it
issue.
is evidence, isn't it? I mean, you can't use it as part of your proof of innocence?
It's hearsay. An acquittal can't come in the next trial.
Well, in a case like this,
assume it.
were we to
Or if it
proceed
does
to
come in,
trial,
it's not dispositive.
It's not
Well, not
dispositive.
It's just-
But I
it's
don't
just-
even think
it's-
it's admissible.
It's sort of a threshold fact you've got to have.
it is a threshold fact.
Yeah. So, so what have you got here? You've got, at least according to the judge's memorandum, the rejection of a plea bargain. I don't think that proves actual innocence. You've got the acquittal. That doesn't do it. We've just agreed on that. You've got the fact that the judge raised ineffective assistance on her own. So what are we left with?
Well,
The
we have the
exculpatory
testimony that was
evidence?
not offered at the first trial of a Mr. Manuel Franco, who installed a burglar alarm. Judge Zobel, in her September 13th, 2002 memorandum and order, really handled the laboring war here and listed the errors and omissions of Mr. Correia's defense counsel in that first trial. And she excoriated the defendants because they knew what Mr. Franco would have testified. I installed the burglar alarm because hanging over the first trial was this sinister implication that Mr. Correia had disabled the fire alarm shortly before the fire.
Well, that goes to the establishing ineffectiveness, but how is that evidence of
Innocence.
how's that evidence of innocence? Do you mean that you would propose to call witnesses that would testify that he was not the one who started the fire?
I would call the witnesses, for example, who appeared at the retrial, Mr. John Tenner, who orchestrated the investigation and made personal observations.
Would it be a rehash of the criminal trial under a lesser burden of proof? Is that?
I think that's fair to say, Justice Spockford. I think that the proof of actual innocence is by a preponderance of the evidence, so it's not an insurmountable Everest. He
So
can
would
make
you
that.
say that in a legal malpractice claim such as this, you have to have a trial within a trial to establish to the satisfaction of this jury that at least by a preponderance of the evidence he was innocent?
I think that's fair.
And if you, at the summary judgment stage, if you have an affidavit from Mr. Correia or anybody in his position saying, I'm innocent, I didn't do this, would that get you over the bar for summary judgment?
Probably not, because I can envision a situation where a defendant was convicted and was granted a retrial, and at the second trial, better lawyering suppressed damning evidence, guns or drugs or a confession, and that person, I don't think, could come into court waiving his acquittal and say, I get to pronounce my innocence.
Well, the question of law won't get you there, because that doesn't mean you're
But
innocent
what
by
did
any
these
means.
what did these witnesses say that shows he's actually innocent,
Well,
as opposed to what might create a reasonable doubt?
Well, first of all, Mr. Correia himself would testify, and if found credible by the jury, that would go a long way to it. The testimony of Mr. John Tenner, who made personal observations, investigated Mr. Correia, found that he did not have a financial benefit by burning down his own store, that he had not insubstantial savings, that this was the source of his income, that it was very unusual for arson to be done in broad daylight where the owner is right there, that Mr. Tenner also made observations that, or Mr. Correia would testify that he had been raking up, cleaning, that there was cigarette butts in the area. I think Mr. Tenner made that very explicit observation. So I think there is enough that the legal nicety that was erected by the trial court below, which based its decision on the fact that Judge Zobel in the retrial let the case go to the jury. That was the explicit foundation of the entry of summary judgment for the defendants, that if it was so patent that he was not guilty, Judge Zobel would not have let the case go to the jury. But that's not true. A presiding judge presented with a motion for acquittal, a motion for a directed verdict of not guilty, has enough on his or her plate then to add how will this play in a subsequent legal malpractice claim.
In any case, it would be an improper consideration.
I think it would, Judge, clearly, because also a judge presented with such a motion is required to view the evidence in a light most favorable to the
Absolutely.
prosecution.
Absolutely.
So are you saying that in every case where, forget motions to suppress, a defendant is acquitted, he could bring an action against his lawyers saying I'm actually innocent because I had witnesses that got me acquitted?
I think,
Where do we draw the line?
well, a case in the instance where I said that he got the acquittal because damning evidence was suppressed, I think he would lose on summary judgment.
Yeah, well,
in
we're
the
not talking
Superior
about
Court.
that. We're talking.
But
I'm
if
talking.
he's acquitted, how would there be a legal malpractice claim? He's acquitted, so
He's acquitted at the second
He was
trial.
it would
acquitted
have to
on the
be-
second
It would have
trial.
to be an acquittal in a second trial with new counsel and new evidence, so you have to
Okay.
have
That's
many
right.
conditions.
Judge Zobel sua sponte brought him, he was in prison. She brought him back sua sponte, saying, you know, I don't
I
think he got good
understand.
representation here. And she released him on personal recognizance and set in motion the events that led to the retrial and acquittal.
Yeah, but that's not, none of that is, you can't use that as evidence.
Well, not as evidence, but the entry of summary judgment was predicated on the fact that Judge Zobel let the case go to the
Okay, no,
jury,
I
let
agree
them
with you
sound
there.
the
I agree
trumpet
with that.
instead of her doing
Well,
it.
let me ask it this way. Supposing this case had not gone to summary judgment, and there was a trial, and the only witness at the trial was Mr. Correia, and he got up and he testified and
I
gave
didn't do
one sentence. I didn't do it. And he said it in such convincing form that the judge decided to let the question go to the jury, and the jury said he wins. And then now there's a motion for judgment NOV because the evidence is not sufficient. Should the motion for judgment NOV be granted because that testimony was not sufficient to support a jury's verdict of actual innocence?
Yes, if there's no other evidence, then it's up to the defendant to come in and say, well, here's all this other evidence. In other words, if they don't
It's an
put on a
interesting
case,
question.
but
Could
if they
with
don't
some-
put on a case,
Right.
it's a civil case, it's evidence, he's saying I'm innocent. Well, you can't be innocent because you're just convicted by a criminal case over there. No, I was acquitted over there. I'm innocent. No other evidence? I mean, what they're going to do in this case, presumably, is come in and say whatever evidence they want to bring in, which was part of the what are the underlying
Your point is that would
indictment?
be sufficient. That would be, your point is that would be sufficient,
I
and it's a
think
jury
it-
question.
I think it
Wh-
would
why,
be.
why
if
is
he-
it any different than some victim gets up and says, I was raped?
No, because
There's no
the
other
ju-
corroborative
No,
testimony.
because the jury would be instructed that in order to bring back a verdict for the now plaintiff, you would have to find that the plaintiff is innocent of this claim. And
By
so
a
the-
preponderance of the
preponderance.
evidence. By
So
preponderance.
then the jury was finding in answer to special questions would be that the plaintiff was innocent. So that would be it, and there would be sufficient
It
evidence.
might well be, but in my
It would
case,
be
we
s-
don't
it-
have
it-
just his protestations of innocence. We have these other witnesses.
No, but also the defendants will put on their case. They will
Absolutely.
put on whatever evidence there was that led, presumably, and other that led to the indictment in the first instance. So you're not going to have the pure hypothetical. If you have a 10-second, 10-minute, period of evidence that it's live, you swear on the jury, he gets up, I'm innocent, everybody lists, and they come back and say he's innocent? No.
There's a defense to the case. There are witnesses that get up in the defense.
Sure.
And the judge denies a motion for a directed verdict. Case goes to the jury, and the jury comes back with a plaintiff's verdict. Now there's a motion for JNOV. Can a judge set aside the verdict?
No.
Well, I think that
I think the answer, counsel, is that's not this case.
that is. Thank you, Justice Marshall. That's not this
I think
case.
you tried to say that before.
Except that how much evidence does a plaintiff need in these circumstances to get to
To
the
a jury.
jury?
He needs to be credible himself. He needs to offer witnesses, as Mr. Correia can do. It was only a burglar alarm. It wasn't a fire alarm that he mysteriously turned off. He turned off the burglar alarm at the start of the business day, perfectly ordinary event. He has Mr. Tenner, who launched the investigation, who made observations in neighboring buildings, learned that there had been vandalism in neighboring buildings, that he personally observed char marks in a nearby building. His investigation that Mr. Correia had money in the bank, did not stand to benefit from burning down his store, that it was his support for his wife and 2 sons. The issue I think that we're talking about is that if this case goes to trial, the defendants are armored with due process. They are participating in the case, putting their own witnesses, their own experts, cross-examining Mr. Correia's witnesses, arguing to the jury, making motions, helping to craft the instructions. Whereas Mr. Correia, after all he's been through, is denied his day in court because Judge Zobel followed the better practice and let the jury sound the trumpet of acquittal.
But
So this
what are
really
you
is-
going to need for evidence to get over a motion for summary judgment? I mean, I understand your point, but you could have in every such case where there's an acquittal after a reversal, the plaintiff, the ex-defendant, now plaintiff would come in and say, file an affidavit, I was at home when this robbery was committed. And he'd even have an affidavit of his mother and his sister that they were at home when they saw him watching television, what you hear all the time. And then is that going to be enough in every case?
It depends.
I don't know, but in my case, I think we have more than enough because so much of what is proffered depends on the jury's assessment of credibility. It was wrong of the court below to pin this decision on the fact that Judge Zobel let it go to the jury. And actually, not only is that the better course, the jury acquittal is final
No,
and
well, you may be
non-appealable.
right. You may be right that that the decision below shouldn't have turned on that. But I'm saying if we agree with you, then how do we formulate the standard? What are we going to say?
Well,
Or haven't you thought that we might agree with you?
Well, it's a summary judgment standard that says there's a disputed issue of material fact. Fine. There's a disputed issue of material fact, so you get over summary judgment, except where, as a matter of law, a court concludes for some reason the disputed facts are not material. And here it seems to me that what the judge in the Superior Court said, as a matter of law, the fact that the judge in the Federal District Court let it go to the jury, as a matter of law, none of the disputed facts are material. That's the issue here.
I think
And
that's
I think
correct.
the answer to that is what the judge was doing in a criminal case, letting it go to the jury, is a different standard. It has to, as you say, it has to be in the light most favorable to the
non-moving party and to the prosecution, and in the
So
summary judgment.
whether or not simply saying, I am innocent and I have had an acquittal is enough to have a disputed issue of material fact to let it go to the jury, we don't have to decide that here.
I don't think we do. I think this case turned on the erroneous erection of a barrier to the case proceeding to trial, not countenanced by mass law, and by a weighing of credibility, which should be the jury's province.
Why shouldn't we establish the standard in Tibor versus Superior Court, the California case? Is that what the judge in essence did here?
Well, I think it was an error, Judge, because for the Justice Cordy, for the reasons I've mentioned, the considerations that Judge Zobel faced were not to think ahead how it might play in a subsequent legal malpractice suit.
Well, that wasn't her function.
Correct. She had to view the evidence in a light most favorable to the Commonwealth, and when the jury sounded its acquittal, that's final and non-appealable. So it was better for Mr. Correia to have the jury declare him not guilty than to have the judge direct a verdict which could be appealable.
Thank you,
Thank you, Justice.
Mr. Ballison. Mr. Murphy, good morning.
Good morning. May it please the Court, I am Robert Murphy. I represent James Fagan and Goldrick in this matter. The judgment of the trial court in this action, finding that plaintiff failed to meet his burden of proof to establish actual innocence, was supported by both the facts and the standards set forth in Glenn
We have
versus Agan.
material issues of disputed fact.
There are no issues of disputed fact.
Why?
Material to the adjudication of the claim, Your Honor.
Explain.
The evidence in this case and the evidence submitted in the summary judgment record consists of the uncontroverted facts that Mr. Correia was alone at the time of the occurrence, that nobody had access to the building.
But what difference does that make?
Your Honor, it was based on the totality of facts at the summary judgment hearing. If you're concentrating on his allegation of innocence,
Did he have an affidavit?
he does not, Your Honor. The only evidence in the summary judgment record is the suggestion that during a plea discussion, he informed Mr. Fagan that he was innocent and would not accept the plea.
Then what is all of this recitation in the Superior Judge Court's memorandum that goes, I'm not going to draw an inference of actual innocence. I'm not going to draw second, third, fourth. I'm not going to draw an inference of actual innocence. I mean, any one of those may not be sufficient to prove actual innocence, correct? But we're on a summary judgment record here.
I understand that, Your Honor, but if we deal with each of those in turn, first we have the protestation of innocence by Mr. Correia. That was done during the handling of the criminal action and has not been repeated. The suggestion that he was innocent, of course, is a shorthand expression for a lot of subsidiary facts. Mr. Correia has not alleged that he did not set the fire, that he was not...
What did he file in opposition to the motion for summary judgment? Anything?
The procedural record was that plaintiff filed a motion for summary judgment.
Right.
Not on the issue of actual innocence, but just on the standard of care that the defendants owed. There were cross motions filed by each of the defendants opposing his motion for summary judgment and cross motion for summary judgment. The trial court found for the defendants on the summary judgment and denied plaintiff's motion. The appeal is
I
only
understand
from
the
the
denial.
denial.
I don't think that...
I know it, but what...
The pleadings,
the defendants
the
moved for
discovery documents,
The defendants moved for summary judgment, saying you can't prove
Actual innocence.
actual innocence.
that's correct.
And
What did he file that proved actual innocence? What sort of
to show
affidavit?
that there was a material issue, a disputed issue of
Yeah.
material
Did he file
fact.
an affidavit? You said no.
Correct, Your Honor. He
What
did not
did he
fi-
file?
He filed deposition transcripts. He filed answers to interrogatories. And I
Deposition
believe,
transcripts of his own? I mean,
I don't recall, frankly, if plaintiff filed his own deposition transcript. I do not believe he did. I could check the record for you. But on
Depositions of who?
the depositions in the case of attorneys Brown and Fagan.
Which, among other things, talks about the settlement discussion?
Not in any significant,
but
there's like
Did
a
he
one...
file the transcript of the, in opposition, did he file the transcript of the second trial?
No, Judge Muse wrote in his summary judgment decision, here Correia, the plaintiff, fails to offer any new evidence discovered subsequent to the second trial which would tend to prove his actual innocence. Rather, he relies on the following, his blah, 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 all past history.
All of which led to an acquittal, which has
Right,
a
but he
higher...
filed nothing. That's what the judge based his whole decision on, was that there was no new evidence after the second trial that was
But he doesn't
filed.
need new evidence after the
Does it-
second trial.
Did he file the transcript of the second trial?
No.
He did not, Your Honor, despite Judge Muse's invitation to do so.
Judge Muse's indication of what?
Invitation.
Filed
Oh.
There's a
Well,
footnote.
isn't that critical? I mean, that's not before the court, so the judge can't look at all these witnesses. Did he file, what about all these witnesses he's talking about?
Your Honor,
The
it's a red herring.
investigator and all, was there affidavits from them?
There were no affidavits from them, Your Honor.
They're all they're in the trial transcript as testifying, right? But that wasn't filed.
Portions of them were, I believe, Your Honor, but the transcript in toto was not filed.
Was the acquittal
Oh.
filed?
I don't know if it was.
So that wasn't in dispute.
Is there somewhere evidence before the trial judge that he was acquitted?
That's not in dispute, Your Honor.
Not in dispute.
I don't know if the actual document itself is filed.
Well, they'll have to if it's not in dispute.
And there was no evidence of alibi.
There is no evidence of alibi, Your Honor.
In fact, there was evidence that he was there.
It is not disputed, Your Honor. He was there, he opened up the store, he turned off a burglar alarm, and he was the only person present during the period of time from when he opened up the store until the fire was discovered.
But what about the witness who testified at the second trial who didn't testify at the first trial?
There were two witnesses, Your Honor, Mr. Manuel Franco, who installed the burglar alarm in 1992. He, in fact, established, as he was called as a government witness, that the burglar alarm had a fire alarm component to it. And although it didn't have the smoke detectors that you would ordinarily see, there was a push button. When you push number 8, it would send a fire alarm off to the alarm company. The second witness was Mr. Tanner. He was an attorney who was hired by Travelers Insurance Company, the insurer on the property itself.
Is that in this record?
Yes, it is, Your Honor.
Okay.
Mr. Tanner,
And it's in this record how?
it was attached as exhibits to the motions for summary judgment, Your Honor, which have been presented to the court in the
The
appendix.
transcript?
I'm sorry.
Your motion or somebody else's motion?
I believe we all appended portions of it, Your Honor.
I see.
Okay.
And he
and
said
this-
this guy, in substance, Mr. Correia had no financial incentive to commit arson.
Your Honor, the two issues. Mr. Tanner was an attorney who was retained to conduct an overall view of things. Most of his testimony was hearsay based on others, and his conclusion was there was insufficient evidence for the insurance company to deny this claim. And that ultimately goes to the issue here. Under the facts of this case, no party can prove the issue here beyond to the
Mr.
standard of care applicable, whether it's a preponderance of the evidence in the civil action or beyond.
Well, the
a
fact that
reasonable
the
doubt.
insurance company, Travelers, should not have denied the claim is not proof of actual innocence, is it?
Your Honor, it is proof only that Travelers Insurance Company chose not to contest the insurance claim.
Mr.
It is
Murphy?
not evidence of actual innocence.
Sure. Let me ask you this.
Yes, Your Honor.
And you can hear what's troubling me is that at the summary judgment hearing and in the discussions, we've gone through, this is not proof of actual innocence, this is not proof of actual innocence, this is not proof of actual innocence, this is not proof of actual innocence. Somebody getting up and saying, I'm innocent, may or may not be proof of actual innocence. It seems to me, though, that ultimately, whether all of the circumstances are sufficient to establish by a preponderance of the evidence that the jury believes he is innocent, is a question quintessentially for the jury unless you can say you couldn't get this evidence in or this wouldn't be admissible. That's a classic summary judgment standard.
I
That's
understand your
that's the
position, Your Honor.
It's not a position, it's just a difficulty that I'm having, so that when you have somebody who makes a claim of actual innocence, And that's the basis of the legal malpractice. It's not just any acquittal. That may not be in and of itself enough, but here you have a whole variety of other pieces that he says the jury, based on those, not just the acquittal, might conclude that I was innocent.
Your Honor, if I might, I'm not going to address the individual facts because we've dealt with that in our brief, and I don't believe anything that he's raised creates any evidence in his favor on the issue of actual innocence.
Any evidence or by itself? I mean, because
Any evidence, Your Honor. I share with you the difficulty in addressing the manner in which you evaluate this, and able to reconcile that as follows. The malpractice claim in a criminal defense case adds an additional burden on the plaintiff of actual innocence. And by that, he has to prove that he is not guilty of the crime charged.
And I take it one way he could do that is to have filed his own affidavit saying, I did not commit this crime.
Right.
Or, if the circumstances were different than they are in this case, he could file an affidavit of someone that says an alibi.
I would
And
agree
he
with...
has done neither of those things in this case.
Correct. I would agree with the latter, but not the former, Your Honor.
that's my problem. Let's assume that he doesn't have an alibi. Because he doesn't. He's not going to concoct an
Correct.
alibi.
And in a case like this, where he has the burden of proving a negative, he has to come forward with sufficient affirmative evidence. in
No,
which
he has to prove a positive.
He has
Yeah.
to prove he's not guilty.
No, he's got to do more than
No,
that. He
he's
has to prove
innocent.
that he's innocent. He has to prove more than he's not guilty.
And he may not be able to prove that by any one thing, like an alibi. Even if it were an alibi, I assume that we would be sitting here saying, well, an alibi isn't enough to prove actual innocence. No, that's correct. It's a disputed issue of material fact.
It may be sufficient, however, to get him over the bar. We would submit that he has not reached that point in time because he is only relying on the plea of innocence that he entered in the criminal court, and there is nothing else in the record that supports his contention that he was not responsible
Well,
for
we
the
will
fire.
look at the record, but at least that doesn't seem to be the basis of the Superior Court judge's ruling.
The Superior Court judge dealt with the 4 issues that he raised at that level, whether and to what extent the acquittal by itself was sufficient.
No, it's not. It's not by itself sufficient,
I
but it could be used as evidence.
I understand the cumulative effect of it, but he ruled out each of the 4
I
components
understand,
as
and
a
that's my
matter of
problem.
law as not relevant. And so if
But
or
if he's
else,
wrong on that, if acquittal is relevant, right? If he's wrong on that, then there's a disputed issue of material fact.
that would be, if he
It
was wrong
won't
on that,
prove
Your Honor.
it. It won't prove it. He's perfectly correct. I mean, the Superior Court judge is absolutely correct to say, as he does, that actual innocence differs from the establishment of legal innocence.
Correct.
And then he goes on that an acquittal isn't sufficient. But here, the issue is there a disputed issue?
Again, Your Honor, coming to the disputed issue, if we would submit that's not admissible, but even if it were, it is not probative of the issue of actual innocence. With regard to the 2 witnesses that he has, they do not address the issue of actual innocence. They may have some facts which establish tangential points which may form
From
part
which-
of his
and from-
circumstantial case. But on the totality of the evidence, the plaintiff failed to produce any evidence which established his actual innocence.
And I suggest that that is not the summary judgment standard. That's the ultimate standard.
The summary judgment standard here, as we articulated, Your Honor, is whether by a preponderance of the evidence, no reasonable juror could conclude that he
No,
was
it's
guilty.
whether it's a disputed issue of material fact.
I'm sorry, Your
It's
Honor.
whether the plaintiff can establish,
Your Honor,
based on whether the plaintiff can in fact establish the fact.
correct.
The plaintiff's burden.
Correct.
So the issue on summary judgment is whether, based on the evidence, the plaintiff can actually, as a matter of law, establish the fact.
Correct.
From the undisputed facts.
Thank you, Mr. Murphy.
Thank you, Your Honor.
Mr. Connell?
May it please the Court, my name is John Connell. I represent the defendant, appellee William A. Brown. Your Honors, I believe the issue before this Court is what evidence must the plaintiff provide at the summary judgment stage in order to overcome the significant element that this court required in Glenn versus Aiken? I agree with Chief Justice Marshall that it is the standard summary judgment standard, which is based on a preponderance of the evidence. This plaintiff has convinced this judge or this trial court that in its own mind there's some disputed issue as to the element, the factual element of innocence. In this case, the plaintiff provided no evidence whatsoever that he did not commit this crime of arson, except for the bare denial that he did it.
And where does that occur, the bare denial that he did it? In the summary judgment record?
The summary judgment record is actually deficient in that he doesn't state that under oath. What he states is that he told his attorney that, and that he pled not guilty. That's the sum and substance of the factual evidence that the plaintiff provided.
And where does that occur, that he told his attorney that he was not guilty or that he was innocent?
I believe that is in his deposition transcript. The plaintiff filed a number of transcripts in support of his own motion for summary judgment, which was filed first.
Okay.
In response, the defendants filed their own motions for summary judgment with transcripts. The defendant, or the plaintiff, there did not file anything in opposition, but merely relied on the record as it was.
So on what he had filed in support of his own motion?
Yes. And it was at that point that Judge Muse, wanting to see the record in total, the trial transcript from the second case, wanting to make his own determination, actually entered an order requiring the plaintiff to produce the transcript and file it with the court. The plaintiff, through counsel, objected to the cost of having to do so, and the court accepted that, and thereafter decided the case based on the record as it was.
How long was the second trial, just out of interest?
As I recall, I think it was 6 days. I may be.
So it's a significant cost.
Yes, I think it was approximately
Mr.
$3,000.
Mr. Cannell, given everything that's been said, that the acquittal in the criminal trial doesn't prove actual innocence,
That's correct.
on what basis was Judge Muse saying, I want to look at the evidence at that trial?
I believe Judge Muse wanted to review this record for his own benefit to determine the plaintiff was not really helping the judge in providing any evidence of actual innocence, other than to say that he denied the charges, he was acquitted. Judge Zobel, sua sponte, raised the issue of ineffective assistance. The plaintiff was not presenting the actual testimony of the second trial witnesses that didn't occur at the first trial that allegedly established some doubt as to whether or not he caused this fire.
And presumably, the judge wanted to see the trial transcript so that he could make his own assessment as to the strength of the defendant's case. I mean, did he establish a reasonable doubt, or did he really go way beyond it?
I believe we could assume that, Your Honor. But the plaintiff did not provide, and is to this date not provided, the testimony that he relies on in this court that he did not cause this fire. I think if this court is struggling with how to best articulate what a plaintiff must show at summary judgment in conformity with Glenn versus Aiken, is that the plaintiff must show some exculpatory evidence that he did not commit the crime that he was charged with. It's a significant element that this court introduced.
That's a very, very difficult, that's a very difficult, for example, I can understand that when, for example, you had a guilty, if you had a guilty verdict, and then on a motion for a new trial there was a legal reason why the motion was denied. For example, it was waived by former counsel or something like that. Then I can understand the exculpatory coming in, saying, here was this exculpatory evidence, my lawyer knew it, my lawyer blew it. So I can see it in that situation.
If this defendant had filed an affidavit, his own affidavit, saying, I did not commit this crime, would that have gotten him over the hurdle?
Absolutely not, Your Honor. That would render this court's decision in Glenn versus Aiken superfluous for every criminal defense attorney that faces these types of civil actions in the future.
But couldn't a jury believe the defendant's own statement? If he offered nothing other than that, couldn't a jury's verdict be supported by his testimony?
Certainly, the defendant or the plaintiff in this case could come to the jury and testify that he, in fact, did not commit the fire or cause the fire.
And if he offered no other testimony?
If that were the end of the case, a 1 5-minute witness, that would be the end of the case. Yes, Your Honor.
And
But-
he could, and the jury could believe him, right?
A jury could believe him.
Would that be proof of innocence, though? That's the question.
Your Honor,
If there's no other evidence.
if there's no other evidence, but it would render,
So why wouldn't that testimony at trial, if reduced to affidavit form for purposes of summary judgment, be sufficient to defeat summary judgment?
well, I think it would be a self-serving statement that
I-
really
so
should be
what?
given
So
no evidentiary weight.
But people do that all the time with summary judgment. I mean, all it has to be is on personal knowledge. Nobody says it can't be self-serving.
Your Honor, this is a particularly isolated line of cases in that this fire occurred 4 years before my client ever knew of this person's existence. Nobody but this plaintiff can honestly say whether he caused the fire or not. Therefore, in an ordinary civil case, Your Honor, where the parties are in an ongoing relationship, either contractual or tort, they have equal access to the originating facts of a dispute. In this case, an event occurred in 1996. My client became involved in 2000. He cannot, in 100 out of 100 cases, a plaintiff in this type of case would say, in order to, it would take the summary judgment option to defendants off the table if all a plaintiff were required to do was simply deny the charge.
Well, he didn't even do that here.
That's correct, Your Honor.
Okay.
Thank you, Mr. Cannell.
Thank you.
Better take a break. It's gonna be a long day.
I will take a short break.
All rise.